Good afternoon, everybody, and welcome again to another episode of Lunch and Learn. And up for this discussion today will be the question of how to apply for a emolument attachment order, as we know in practice, a garnish order. Now, that is something that all of us at one stage, if we deal with maintenance matters, have come across this type of question. How do you actually apply and how does it work, the emolument attachment order or the garnish order? So what we'll be discussing today, if we just have a brief overview of our discussion today, is we will be discussing the statutory requirements of emolument attachment orders, and that we will find in sections 28 and 16.2 of the Maintenance Act. We'll have a discussion on that, and we'll explain to you exactly what is an emolument attachment order and how does it work. We will also explain to you when you can apply for emolument attachment order or for a garnish order, and what documents are needed and in order to be completed, in order to give effect to an emolument attachment order, and how is it enforced. And then the burning question of what can one do if the employer fails to comply with the garnish order or the emolument attachment order, and can a employer actually refuse to deduct money from the respondent's salary or his wage in order to give effect to the emolument attachment order. And then we'll have a short discussion on the prescribed form and the application procedure of emolument attachment orders. And without further ado, if we get started on that, just before we get into some logistics, if you have registered on www.lunchandlearn.org.za, you would have received a link bringing you to our website, where you would have access to obviously some pre-reading material. For this webinar, there is no pre-reading material, but you would also have received the link of this webinar, and then most importantly, the resource and templates tab right at the top on the right hand side of your screen, where you could have download opportunity for the handout, which is a complete handout pertaining to this specific webinar on emolument attachment orders, that was generously compiled by Erin O'Neill, which is a candidate attorney at our firm. On the resource and templates tab, you would also have, like I said, the slides, the handout, as well as a copy of all the slides that we would be using, as well as the documents that we refer to during the course of this webinar. But without further ado, just by way of introduction, I would like to explain to you briefly what about emolument attachment orders. Now, initially, the emolument attachment orders, or the garnish orders that we know, was used as an enforcement tool of a certain judgment. Now, long before the amendments was made to the Maintenance Act, there was a provision in the Magistrates Court Act allowing for deductions from the wages of a respondent or a default creditor, judgment debtor rather, to deduct money from his salary in order to enforce a judgment that was made by the court. Now, so the provisions of the Magistrate Court Act contained in section 65J specifically of the Act was there long before the Maintenance Act was actually drafted and put into place. So that is just the history where it comes from. So the intention of the legislator was clear, that there should be a mechanism where a defaulter should be forced by means of his employer, if he is obviously employed, to deduct certain monies from the salary of the employer, and that money need to be paid over to the person who was owed that specific money. So if we come back and we bring it back to the Maintenance Act, the emolument attachment orders is used in terms of the Maintenance Act as both a compliance tool as well as an enforcement tool. And we'll be explaining that in some depth. And we will be discussing section 16.2 specifically of the Act, that deals with a compliance, and then the enforcement, usually when a person is in arrears, in terms of section 28 of the Act. But that would become clearer as we proceed, as we go along. So in short terms, or in basic terms, what is an emolument detachment order? An emolument detachment order is basically a court order, either in, if you bring it back to maintenance, in terms of section 16.2 of the Act, or section 28. So that's a court order, or it could also be by consent. But the bottom line is that there should be a court order that was made. That court order is then, and that is the court order authorizing the sheriff of the court to go to the employees or the employer's workplace, or the employee's workplace, and serve the necessary documents on the employer, forcing the employer to deduct a certain amount of money per month to be paid over to the complainant, or in this case, the mother, if it is the mother that applies for maintenance. Obviously, there's some administrative stipulations in the Act pertaining to the deductions thereof. For example, and we'll explain that briefly, is that the employer is entitled to deduct an amount of 5% of the money as an administration fee before that gets paid over. And there's also a couple of obligations placed upon the employer that he needs to abide by. And then there is also a penalty clause to say that if the employer does not deduct that money, it is considered to be a criminal offense. And we'll be discussing that in some detail in a while. So there are certain sections, or a couple of sections in the Act that deals with the emolument detachment orders, or the garnish orders. And I'm making reference, and this might be a good idea, that you get the Maintenance Act, and you take the Maintenance Act and then you actually read through these sections in order just to give you an indication of how it's dealt with and how does it all fit together. In terms of the Act, section 16 deals with maintenance and the auxiliary orders. We will be discussing section 16.2 in quite some detail in a moment. And then section 26, that you'll find in chapter 5 of the Act, that deals with the enforcement of arrear maintenance, with specific mention made to section 28, dealing with emolument attachment orders, or the attachments of emoluments. Section 29 deals with notices, or notice relating to attachment orders. And then section 38, the offenses that deals with these type of orders. I also made mention of section 65J of the Magistrates Court Act, that also deals with emolument attachment orders. It might be a good idea to read that hand in hand, because there are certain case law pertaining to emolument attachment orders, and that you would find mostly in the Magistrates Court Act, with reference to the Magistrates Court Act section 65J. But those are all applicable to maintenance matters as well. There's a couple of regulations that also deals with maintenance, or the emolument attachment orders, and those are found in Regulation 16, the application for the enforcement of maintenance or other orders. Regulation 20, which deals specifically with attachment of emoluments, and then Regulation 22, complaints of failure to comply with orders, and then service of orders contained in section or Regulation 26 of the Maintenance Act. So as a point of departure, and it's important to note that there is a difference between the periodical payments, the monthly payments of maintenance that is made an order of court in terms of section 16.2, and the attachment of emoluments by way of application to court for arrear maintenance. So you've got the two sections. You've got the one where it is an order for the monthly payment of maintenance, where you want a garnishing order for, and you would have one for arrears. So those two need to be distinguished quite a lot. The attachment of the salary or emolument will be authorized by court only, on application, or when the court suspends a warrant of execution, or an order for attachment of debts. And I'll explain what I mean by that. And that comes very pertinently when you want to apply for a garnishee order or emolument attachment order in the event that the debtor or the respondent is in arrears. At present, there's no prescribed form for an emolument attachment order. and the magistrate should note that on the record of the proceedings and the particulars of that order as to the amount that needs to be paid, when it should be paid, the frequency, and as well as the details of the employer should be reflected on the notice to the employer referred to in section 29 of the Act. And that is in the event that the respondent is not in arrears. So let's look at the discussion of Section 28. So Section 28 is found in Chapter 5 of the Maintenance Act, and that deals specifically with the enforcement of arrear amounts. So you would have an option, like we discussed in the previous webinar, of the enforcement of arrear maintenance. And Section 28 deals specifically with the attachment of emoluments, or the garnishee, where it says that Section 28, the provision reads as follows: a maintenance court may, upon application of a person referred to in Section 26, that's the complainant, or when a court suspends the warrant of execution or suspends the order for attachment of debt, or where applicable, and after hearing possible evidence, either in writing or verbally and orally, of the employer of that person in question, then make an order for the attachment of emoluments at present or in future owing. So that money is something that could be accrued in future, like a normal salary, against the person whom the maintenance order in question was made, for the total amount to cover that amount that the person is in arrears for, or that he failed to pay, together with an interest thereon. And then the document would be served on the employer in terms of an emolument attachment order. So the court makes provision in Section 28 specifically for the issuing and the granting of an emolument attachment order, but there's a provision in terms thereof. And like we said, we discussed that in a previous webinar, and I'll just jump a slide quickly and I'll come back to the previous one, is that you can only apply for one of these type of remedies for the enforcement of maintenance when the maintenance debtor or the maintenance respondent is in arrears. You can either ask for a warrant of execution against property or an attachment of debt, or you could apply for a emolument attachment order. So what we say when what we mean by choose your lane, the court is the Act is very specific when it says that you can only choose one of these avenues. You can either have a warrant of execution or an attachment of debt or a garnishee order, but you cannot have a combination of all those three. And that is why, if we go back to the previous slide, dealing with Section 28, when Section 28 specifically says that, you know what, only upon the suspension of a warrant of execution or the suspension of an attachment of debt order, then only can you apply for a garnishee order. So you cannot have a warrant of execution running in the background. You know what? That's where they attach the furniture or the movable goods of the respondent in order to be sold by public auction, and that is now to cover enough proceeds to be sold by public auction to pay for you as the person that is in arrears. You know what, the money that needs to come to you in terms of arrears. So that needs to be suspended before a garnishee order or emolument attachment order could be issued. And this is just amplification of what was already said in the previous webinar when we dealt with the enforcement in general. But Section 28 definitely it could be used. That would only be used to obtain or to have a garnishee order granted when the respondent is in arrears. Now, there's a very important provision also contained in Section 28 1D of the Act, where it says that provided that nothing precludes the court from making an order in terms of this subsection, if it is of the opinion that any other further postponement or inquiry in the order in order to obtain evidence of the person referred to in this paragraph will give rise to unreasonable delay in the finalization of the inquiry to the detriment of the person or the persons to be maintained. So what does that mean? What is Section 28 1D then means? It says that the court may, if there is an unreasonable delay, and it necessitates a postponement in order to obtain evidence that needs to be led. And it would give rise to an unreasonable delay in the finalization of the inquiry. That is now either the section 10, or it might be a section 6 inquiry. Then the court might be in a position to grant a garnishee order. 1D is not very often used. It's very much overseen by many of the maintenance officers in court, but you are well within your rights to ask them. But you know what, in the interim, if the matter needs to be postponed, that you could actually ask for a garnishee order that could be implemented immediately because there is an unreasonable delay in the finalization of the inquiry, and there is a need for the court to, there's actually a reason for the court to postpone the matter in order to obtain some further evidence that needs to be led or to be presented to court. Just an amplification of what we said, there's only one of the three options in terms when it comes to arrears, not when a normal section 6 inquiry or a consent order or a normal process, but this we're only dealing with arrears now. Then you have to choose one of those three options, and not all three of those options could be used simultaneously. In the discussion paper 157 by the South African Law Reform Commission, fortunately I was on the panel discussing that and making submissions to the South African Law Reform Commission. We dealt with this extensively, and we actually recommended that one or two or even a combination of all these three avenues should be sought so that one could not be excluded and given priority above the other one. So you would be, if there are changes to the Maintenance Act and the submissions has been followed, then in all probability you could use more than one avenue. But up until that stage that the Maintenance Act has been changed or the amendments have been effected or published, or even drafted in properly for submission. At this stage, as the Act stands, you could only use one of the avenues mentioned into Section 28. So now we come to Section 16.2. So Section 16.2, now we've got nothing to do with arrears. Forget about arrears. Arrears, if you think about arrears, you think about Section 28 with the provisions that allows you to get a garnishee order. But Section 16.2 of the Act deals with attachment of emoluments or garnishee orders, and it reads as follows. It says that any court that has at any time, whether before or after the commencement of this Act, made a maintenance order, so obviously at any time now after the Act has been effected or the commenced, it would necessitate and give you the opportunity to apply for a garnishee order that makes such a maintenance order or that convicts a person in terms of an offense in terms of 31. And we'll get to that. I'll make a mention of that later. Shall make an order directing any person, including the administrator of a pension fund, who is obliged under any contract to pay any sums of money on a periodical basis, usually a monthly basis, to a person against whom the maintenance order in question has been made, or to make on behalf of the latter person such periodical payments from monies at present or in future owing or accruing to the latter person as may be required to be made in accordance with the maintenance order. That says a lot. That is a lot of big words, and it basically says that, you know what Section 16.2 says, that when the court makes a maintenance order or a person stands to be convicted of an offense in terms of Section 31 for not paying maintenance, then the court may at that stage direct either the pension fund or the employer to do periodical payments, monthly payments, in order to pay for that amount. So the court could make an order right at that stage. So how does that translate into practical terms? In practical terms, it would mean that Section 16.2 could be used at any stage if the respondent is not in arrears, because if the respondent is in arrears, then you would use the avenue of Section 28 in order to get a garnishee order if there is not a garnishee order made yet. But during the whole process, Section 16.2 could be used to apply for a garnishee order to be made. The courts are reluctant, and I just need to make some mention of this, that during the process of the maintenance inquiry, if the respondent appears or even do not appear, the courts are reluctant to use Section 16.2 in making a garnishee order. And what is the reason for that? The reason for that is simply because now the mother goes to court and she says, you know what, she wants 500 Rand of maintenance per month, and everything is hanky-dory. And the court might actually give a court order based on that amount, the 500 Rand, be it a default order, be it a consent order, or whatever the case might be. But let's stick to the scenario where the respondent is not present when an order was made in terms of Section 16.2. The court would be in a difficult situation because in law there is a provision called a rule called the alteram partem rule, which means that you have to hear the other side of the party, or the other side of the argument. And it would place the court in quite a precarious position because they would not have the information of the respondent to say, you know what, I can actually afford that and I cannot afford that. In the past, the garnishee orders system has been misused by so many people as a debt collection process. And with reference to Section 65J of the Magistrate Court, there was quite a number of court cases that dealt with the unscrupulous use of garnishee orders and the granting of garnishee orders. And in one of these cases, Minter versus Baker, it quite clearly says that, you know what, you cannot grant a garnishee order in the absence of the respondent if he did not have the opportunity to come to court to say, I can actually afford that. There should be enough money left for him to support himself and his dependents before a garnishee order is granted. Now, that was an order handed down and given in terms of Minter versus Baker. In terms of Section 65J, that dealt specifically with the garnishee orders. So the courts are reluctant to a great degree of using the Section 16.2 method of granting a garnishee order. And it is clear in terms of case law and Section 28.1, where it says the court should hear evidence of any person. Now, that is specifically referencing to the employer who's obliged under any contract to pay any sums of money on a periodical basis. That's not just paying, you know, what, getting a salary. In question, they should be heard in terms on the practicality of the enforcement of the garnishee order. And that was specifically also mentioned in the case of Rasa in the year 2000, when that was mentioned. It's important to note then that the court can proceed to make an order if it is of the opinion that any other postponement or the inquiry would give rise to unreasonable delay in terms of Section 16.2, although I mentioned that the court's reluctance to do so just as a blanket rule to dish those things out, because with reference to the state versus Rasimila, the opportunity needs to be afforded to the employer specifically to give evidence or to be heard in court before such an order should be given. That is not usually done in courts. Very seldom do we get the situation where the employer would be invited to court in order to give testimony or to give evidence regarding the obligations that needs to be done. The reason for that probably is that the courts, there is certain remedies for the employer to come to court after the order has been served on him, forcing him to deduct the money. Here, there is actually some recourse for the employer to approach the court to say, but you know what, we cannot do this for a number of reasons. We cannot deduct the money for a number of reasons in order to safeguard him from the criminality or the criminal element of not deducting that money. So when can you apply for the emolument attachment order and what documents are needed? Like I said, at any time in terms of if you have a consent order, then a J214 could be filled in. Now, the J214 is usually used when the parties agree to a maintenance amount out of court, when there's not necessary for a Section 10 inquiry in court. you could use a section a J214 form that you could use as a consent form. During that consent form, the respondent can give permission that money be deducted from his wages. Now, if I do, for example, if I, in many of my cases where I do mediation in maintenance matters, I have the parties fill in, even if they come and see me at the office beforehand, I would have the respondent fill in a J214 document or form, that's a justice form, where he consents to an amount of maintenance. And on that form, I also indicate that he consents to a garnishee order. And then that form gets handed over to court, and the court would simply endorse that and make that an order of court, which is brilliant if it works that way, because then there is no need for any other testimony from the respondent in terms of the garnishee order, and the garnishee order would be dealt with by the employer deducting that money. Now, that could also be made during a Section 6 inquiry when they are at the offices of the maintenance officer, where they come to a certain agreement and they say, okay, I'll pay that amount of maintenance, and then the maintenance officer could request and ask the respondent if he consents to a garnishee order, and if he does consent, then that would be noted on the J214 document, and that would be made an order of court as well. It could also be during court proceedings in terms of Section 16.2. That could also be used if the matter goes to trial and the matter is heard and evidence is led in the front of a magistrate, where the magistrate could then, in effect, remembering, what the if it causes undue delay, then the magistrate could inquire from the respondent if he consents thereto, or even then after a financial inquiry, make an order for a garnishee that needs to be deducted from his salary. That is on the one side that you could use. Like I said, we deal with two situations. The one where that is just during the normal process of claiming maintenance. And then there's obviously when the applicant or the respondent is in arrears and you want to enforce the maintenance order and there is no application or there is no garnishee in place, then you can approach the court in terms of Section 28 in order for the court to grant a garnishee order. Remember now that also that the respondent needs to be in arrears for at least a period of 10 days before you can approach the court in terms of Section 28 to apply to court, so to deduct that money directly from his salary. So in most instances, if the person's, what happens in practice is that either the respondent would consent thereto during a Section 6 inquiry or even beforehand, and a J made an order of court, then subsequently, that is during the proceedings, or usually what we also find is if there's a need for the enforcement of arrear maintenance and there is no garnishee order, that the applicant or the complainant would approach the court asking them, I want a garnishee order to be done from his salary because he does earn, he does work, and at that stage, the J306 form needs to be completed. And that is for the enforcement of the arrear maintenance. And obviously, together with that, you need to give to the court and to show the court what amounts is outstanding. So you would draft and attach that to your J306 form. And then in the little blocks that is also mentioned in the handout, the discussion of of how to fill in the J306 form, you mark that portion where it says garnishee or emolument attachment order or attachment of emoluments. You circle that or you mark that area on the J306 and attach there to your schedule of arrears. And then the matter would go to court, and the court might or may very well grant a garnishee order or an emolument attachment order. Now, the J306 forms that I'm referring to would also be found in the handout portion of the discussion, or of the link that you received for all those registered. If you are listening via numerous social media platforms, you could download the J306 by clicking the QR code, or there's also a short code link that you can link for that. It is Form K J306, which is a formal Department of Justice form. If you do a simple Google search, you might be able to find that under the DOJ site as well. So now we come to the question, can the employer refuse to deduct the money from a respondent's salary or wage? And the simple answer there too is no, he cannot do that. In terms of case law, in terms of so many cases that has been decided on this specific issue, and the whole intention of the legislature was that the employer, once they are being served with an emolument attachment order, the deduction of the salary is placed instead of the judgment debtor. With other words, the person that needs to be paid, that needs to pay maintenance. So in all practical terms, with the emolument attachment order, the employer is now being replaced, or the respondent is now being replaced by the employer, and there's an obligation upon the employer to deduct that money. And it is very vitally important that in terms of Section 38A of the Maintenance Act, it is actually a criminal offence if the employer does not comply with that garnishee order. There's a couple of remedies, things that one can do in case that the employer fails to deduct money, or there's also certain obligations what they should do. And if they do not do that and do not adhere to these provisions, that they could face serious criminal charges or jail time or even penalties in terms of non-compliance thereof. Some of them, and I'm making specifically reference to Section 29(2) of the Act, that says, you know what, you would have the chance or the situation where a person is working. So the garnishee order gets served on the employer, and that's everything is fine up until a stage that the respondent then leaves the employment of the employer. And then the garnishee order just hangs in the air and no one does anything about that. You as the mother or as the complainant would not know that he left the employment because you would not get notified unless you have family or you see it on Facebook or someone tells you that he left his employment. But the employer might not even tell you that he left his employment. And there's no obligation for the employer to notify you, but there is a definite obligation in terms of Section 29(2) of the Act that the employer needs to notify the court, the maintenance officer of the court where the order was granted, using the Form O document, Part C of Form O, of the within 7 days that the respondent left the employment of the employer, he needs to the employer needs to notify the court that he has left the employment. If they do not do that, then they are open for criminal sanction, and it is a criminal offence under the Act. With reference to Section 29(3), an employer on whom a notice has been served for purposes of satisfying a debt or satisfying a maintenance order shall give priority to the payments specified in that notice over any other court order requiring payments to be deducted from that salary. Very important. We see that very often where the employer would simply say, you know what, or I cannot deduct the maintenance amount by way of garnishee because, you know what, this poor guy or this poor respondent has deductions for furniture shops, retail stores, for loan sharks, and there's not enough salary to attach. Now, in terms of Section 29(3), it is absolutely very clear. It's very clear that the priority should be given for any maintenance payment as a deduction, garnishee deduction, above any other debt that needs to be paid. And that is now, in terms of case law as well, the only time that a garnishee order will not be deducted, there's not enough money, is when SARS pay the crown. I mean, that's the only time that a garnishee order will not be deducted if a SARS deduction is made on the respondent's salary. But for any other debt, if he has furniture debt, if he has debt for loan sharks or for loan accounts, then the maintenance order will rank right to the top of the list, would go back to the top of the list as a priority deduction. And that is not very often enforced by the pay officers or the payroll officers of the employees. And it's important that they should take note of this And you are also well within your rights to act on this if they do not do that. If they say, but they cannot deduct the full amount because there's no money left at the end of the month for payments because he has so many deductions, then you can refer them to section 29.3 and say, but you know what, that should be a priority deduction of in terms of the garnishee order. Section 29.4 deals with, let me just read through that. If any employer on whom a notice has been served for the purposes of satisfying a maintenance order has failed to make any particular payment in accordance with that notice, that maintenance order may be enforced against the employer in respect of any amount which that employer has failed to pay. Now, like I've said just a couple of minutes ago, I said that in basic terms, it means that the employer is now placed in the shoes of the respondent, of the person that needs to be that needs to pay maintenance. Now, section 29.4 will come to your rescue, and it amplifies what I just said, that if the employer refuses to deduct that money, then that money that needs to be paid over could be recovered directly from the employer. In practice, I've dealt with numerous of these type of cases where a garnishee order has been served on the employer. The employer just drags their feet, or they simply do not pay over the money. And then the parties come to my office and I issue a warrant of execution against the employer, forcing them or the sheriff of the court to go to that workplace and to attach furniture. I had one case where I actually attached computers for the non-payment, the mainframe computers of that company for non-compliance of the garnishee order, because in terms of section 29.4, that judgment or that order could be enforced as if it was against the employer. So if they refuse to do that, then you can very well attach their furniture for non-compliance. Variation and suspension at any stage, if at any stage that even the respondent and or the employer feels that there is good cause that the emolument detachment order or the garnishee order should be suspended, amended, or rescinded, then they can approach the court for such an order, making an application, bearing in mind that you as the complainant or the applicant in this matter should be notified thereof at least 14 days before the application is to be heard. So you would have notice if there's say for example, he leaves his work or he transfers from one work to another, resigns at one and then he goes to another job, then there's the obligation in terms of section 29 that the employee should notify the court. And if the court is notified, then the court would notify you that there would be a good cause or good reason for the order to be suspended or amended, and either to be rescinded. And then that is by way of application. That is done quite often in courts, especially where the garnishee order is suspended for the one work because he resigned or he got a better job offer. So he resigns at the one job and then it needs to be transferred to the next employer. Then we make use of section 28.2 of the Act. Other noteworthy provisions regarding to emolument detachment orders, and I'm referring to section 29, where it says that in order to give effect to an order for the attachment of emoluments, referred to in section 21.8 or 28.1 of the Act, a maintenance officer shall. Now, this is not must or what, or they have a discretion. The maintenance officer shall, within 7 days after the dates on which such an order was made, together with a copy of the court order, the garnishee order, serve that on the employer concerned, directing them to deduct monthly payments. So this is a very, 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 very important provision. Within 7 days after the court order was made, there's an obligation on the maintenance officer within 7 days to send off the documents to the pay office or the payroll office of the respondent so that money could be deducted. So this thing that garnishing orders takes forever, it takes months, even years in order to be implemented, is plain rubbish. In terms of this section, section 29, it says that order needs to be given or needs to be sent through to the pay office of the employer within 7 days, and then usually it takes them a month, a full calendar month, depending on when you get your salary, for them to implement it on their side. And one should be reasonable and to afford them the opportunity to load that onto their system, because there might be cutoff dates and so forth. So usually in practical terms, what that means is that a garnishing order to get your first payment in terms of a garnishing order should take no longer than 2 to 3 months, 3 months at the least. So these respondents or these complainants waiting for months on end for a garnishing order to be implemented is plain rubbish, because it means that either the maintenance officer did not send through. It could only be one of two cases. Either the maintenance officer did not send through the necessary documentations in terms of section 29 of the Act, because they afforded 7 days to do that, within which they have to do that, or the delay might be at the payroll office of the employer as well. That could be one of those two. And for both of those, there are certain remedies. If the clerk of the court is not doing their job, or the maintenance office is not doing their job in terms of the DOJ code, dealing with disciplinary hearings and the process that needs to be followed, disciplinary hearings could be held or could be instituted against that maintenance officer for non-compliance of the certain provisions of the Act, or if the employer is not deducting, then certain remedies could be effected on the side of the employer as well. Another important thing that one should note is that the emolument attachment order, in terms of regulation 26, now this is regulation 26 2B, it could be served by means of faxing or posting. That is now as opposed to delivering that by means of the sheriff. It could also be faxed or posted to the employer in order to effect deductions. Now, nowadays, we do not use faxes anymore, but yeah, we certainly most definitely could make of the faxes or the postal services by registered mail. Even that, we don't have any guarantees that it would get there. So up until a stage, and this is also something that the South African Law Reform Commission needs to address, is the ways of service. And in all probability, we would see that that be changed in order to also to include in future, not now, but in future, to also include service by email and other electronic means. Some other noteworthy provisions is that if the employer leaves the service of the employer needs to notify the court within 7 days. Obviously, we mentioned that in terms of section 29(2). Non-compliance thereof is a criminal offence in terms of section 38, and the document that the employer needs to complete is part C of Form O. It is a justice form and that they need to send through to court. And just to amplify, in terms of section 29(3), the employer must give priority to payment of maintenance over and above any other payment that needs to be deducted, and non-compliance of the notice or the emolument attachment order by the employer is a criminal offence, as mentioned in terms of section 38A. I can just mention that I have done some extensive research on this topic, and I've been dealing with it for the past 23 years, and I have yet to see an instance where an employer is criminally charged in terms of section 38. So it is on the law books, but it is not properly enforced. The usual enforcement tool is usually through the civil courts. So, problems in conclusion. I see that we are running out of time a little bit, slightly. So usually we deal with problems of non-deduction and the delays in non-deductions. You've got one or two, and this is one of the questions that pops up quite frequently on my Facebook groups, or it might, I get emails on that as well, is what to do in cases that they are so long, there's so many delays, and that results in non-deductions. So one of the avenues that you could use is to go to court, fill in the J306, that's the enforcement of the court order, and report the matter to the maintenance officer. I have not dealt in this webinar with all the documents and all the procedures and all the forms, the prescribed forms that the maintenance officer needs to complete. Sending a warning form, sending a warning letter, and the steps that needs to be followed, because that is an internal process followed by the maintenance officer, which goes a little bit out of the scope of this webinar. But if you would like to have more information on that, on the process that the maintenance officer specifically needs to do, then you can email me on info@lunchandlearn.org.za, and I'll give you some background on that as well. But for practical purposes, if there are any problems with the delays in deductions, then you've got one of two options. Either you could enforce the garnish order through the maintenance court. Now, remember, we all know that it might take months, even years, for the maintenance personnel to deal with that issue. The other option that you could use, and we saw a great example of that, is in the Argus versus Argus case, where enforcement could be done through an attorney, where you can approach an attorney, the debtor is in arrears, or the employer does not deduct the money, that you can actually go to an attorney and you can ask the attorney to take steps, and they're well within their rights to do so in terms of Section 24, where it says that, you know what, a maintenance order under the Act, the Maintenance Act, shall have the effect of an order or direction of court made in a civil action. With other words, it is basically considered to be a civil judgment. So an attorney could assist you in doing that. That would obviously mean that you have to pay the attorney out of your own pocket, but the advantages thereof would be that the matter is dealt with very swiftly and very expeditiously, as opposed to the whole maintenance system that allows that for people to do that for free. Like I said, it usually takes a couple of months, if not years, to get the employer to deduct, and that might be problematic because you as the mother or you as the complainant would wait for that money in anticipation and not knowing what's going on, and the maintenance officer having quite a number of files on his desk might not come to your file or might not prioritize your file. In such an event, yes, you would be able to appoint an attorney to act on your behalf and assist you with that matter. And that basically brings us to the end of our discussion on emolument attachment orders. It was great presenting this once again. If you have any questions, or if you have any comments on emolument attachment orders, or if there is something that you need more clarification on, then you're most welcome to send us an email at info@lunchandlearn.org.za, and we'll address that. My name is Eugene Opperman. I'm a family law practitioner. I've been doing so for the past 23 years, so I've seen it all, I've done it all. I specialize mostly in maintenance matters, domestic violence matters, as well as matters pertaining to children, parenting plans, and visitation, and so forth. Many thanks to one of my clerks, Erin O'Neill, for compiling the handout. If you have any comments on the handout, but yeah, please drop us a mail on info@lunchandlearn.org.za. Thank you so much for the time that you've spent with us. We'll be back next week, same time, same place, for another episode of Lunch and Learn. And I wish you all a great afternoon further.